I knew that. Welcome. Welcome. It's Monday and time for the Deal Doctor live stream. Joining me today is Matt Kiproff from Star Title. Hopefully we'll be able to answer some questions and walk us through some issues that we deal with when we get to title work. The question came up, was sent to me last week along this line. When it comes to title work, what are the agent's responsibilities regarding the scope of their responsibility to read through, understand, and advise their clients? My answer is all of the above, everything. It is our job. We are the point person for all of the issues that go on in the purchase agreement, including title work. So I want to read to you paragraph 17 of the West Michigan Regional Purchase Agreement. And it says that the real estate title work shall be provided to the buyer within 10 days of the effective date of the contract. So first and foremost, we owe our clients, buyers in particular, the responsibility to get that title work to them within 10 days of the effective date. We have to order it. If it is with Star Title, for example, if we're going to order it from Star Title, we can submit the title for review with your branch administrator, and that will be forwarded to Star Title. Let's pretend you don't do that. Let's pretend that they don't get it within 10 days. In fact, they don't get it till the last few days before the closing. They have every right to terminate that contract because they haven't gotten the title work. So that's a really, really important responsibility of ours to make sure that our clients get the title work within that 10 days of the effective date. Let me go on. If the buyer objects to any conditions in that title work, they have 3 days of the receipt of the title commitment by written notice to seller to either terminate the contract and refund or to make a proposal for the seller to correct those issues in the title work. Wow. So let's say that 14 days after the effective date of the contract, we as the agent have done nothing regarding title work. We haven't ordered it, we haven't reviewed it, we haven't checked to see if it's in our email, we haven't forwarded it to the client, and now it's 14 days into the contract after the effective date. The upshot of that is that the buyer has no ability whatsoever now to terminate the contract based on the title work. None. We've basically eliminated their ability to respond to the title work. So our duties regarding title work are delivery. We have to make sure that they get it. Disclosure, that is an explanation of what's in the title work, and repair. If there's something that has to be fixed in regard to the title work, we're the ones who get to run point on it. We're the ones who have to make the calls, usually to the title company, to get clarification and to get a clear understanding of what the title company is going to need in order to fix the clouds on the title. So, for example, let's say that in the process of running title work, you discover that there's a mortgage lien showing on the property that, according to the seller, has been paid off, or a second mortgage, or a land contract, a tax lien. Let's say that there are easements on the property, whether they are recorded. Let's say that there's a utility easement or a county drain easement that runs right down a portion of the property where they were going to build a swimming pool, or they intended to build a swimming pool or a tennis court, or put in a fence. And those easements would preclude them from being able to do that. How do they know if we haven't shared that with them? So, if they are in certain areas where a lot of fracking is occurring, do we know whether or not the mineral rights have been sold off or optioned off or leased to a company who is doing fracking? It might show that in the title work. We might have to dig deeper than that, ask for a deeper search of title if there is the possibility of that. So, I'm going to turn to Matt now, and I'm going to say to Matt, my first question, I got a bunch of questions. Hey, if you had one thing to tell agents to look for in title work, what would it be?
First thing is you're going to look at the requirements. The requirements on the title work is a roadmap on how to get to closing. It'll talk about vesting. It'll talk about what is required for your transfer documents, if there's an affidavit necessary, is there correction documents necessary, what kind of deed. It'll then move into the open liens and the rest of the items we find on title work or find on in the chain.
Okay. What kind of liens would you find? For example, you say you find some open liens.
Like mortgages.
Okay.
It can be, they could be tax liens, they could be judgments, there could be all kinds of different things affecting the title, affecting the ownership.
Okay. What's the most common thing that agents miss when they go through the title work?
I would say just reviewing the title work in and of itself is probably the most important aspect that an agent can do with their commitment.
Mm-hmm. So, if I'm hearing you correctly, the first step is you have to read it.
That
to be
is.
blunt.
Yes.
The first step is you have to read it. If there are things in there that you don't understand, then you call the title company,
Absolutely.
whether they're working with you or someone else,
Mm-hmm.
and say, what does this mean? How do we go about fixing it?
Mm-hmm.
Would you agree with that?
Absolutely. You have
Okay.
an agent support person assigned to you,
Mm-hmm.
and they are there to help you and explain anything that's on that title work. And if they don't know themselves, let's just say it's an odd situation, they have the ability to escalate that.
Okay. I actually got a call on the way over here, in my car, on the way over, and it regarded the next question, which is, what should an agent do if they discover that there is a federal, state, or city tax lien on the property?
First thing you do is you call your agent support individual. Once you do that, they should already be working on that. If they're not, for any reason, your call to them will alert them of the issue, and then they will start the curative aspect to that. Your agent support person is there to help you through that. Most of the time, we can obtain the information on behalf of the client. There may be a customer authorization form that may need to be signed, but for the most part, we have the ability to rectify that, get the appropriate payoffs, or find out if it's even our party.
Sometimes there could be an error.
Absolutely.
Common
name.
It may be John H. Brown
Mm-hmm.
that a lien is filed against, and the seller's name is John B. Brown, for
Or
example.
just John Brown.
John Brown. Okay, perfect. So those are the things that it's our responsibility to exercise that due diligence and make sure that those questions get answered. Very often, when there is a land contract on a property, when the property is initially sold on the land contract, there's a memorandum of land contract which is recorded. Sometimes they don't record the payoff when the warranty deed changes hands. And so that memorandum of land contract is still showing on the title work, but not when it was paid off or a mortgage was put in place to pay off the underlying land contract. If we find that there's a memorandum of land contract showing up on the title work, what's the first step an agent should do, or call agent support?
Absolutely. First step is contact your agent support person. Second step is to review that commitment. That commitment should have a series of requirements that involves that contractual interest. If for some reason it doesn't, again, that's going to be your agent support person. You're going to make them aware of it. There may be additional research we may have been able to ensure around it.
Let's pretend just a little farther with that one.
Sure.
There's a memorandum of land contract.
Mm-hmm.
The land contract holder, the lien holder, dies,
Mm-hmm.
and there are 4 heirs to the property, sons and or daughters, 4 of them. Now what does the agent get to do in order to get that lien, get a discharge of lien on that property?
Well, just because one of the parties dies in a contract does not eliminate their interest. Their interest will convey or move to their heirs. So you're looking at probating an estate and going through that court process to get yourself a personal representative in order to sign on behalf of that estate. And once that's done, and the court assigns that person, that's who would sign those documents for closing.
I'm going to challenge you here, Matt. Actually, I'm going to challenge the agents. Let's say that this memorandum of land contract shows up nice and big on the Schedule B, and the agent hasn't read it.
Okay.
And we get 14 days, 18 days down the road. Does the buyer have the right to walk away from the contract at that point?
If we don't give them an opportunity to object to, one, get the title work in the appropriate amount of time, object in the right way in the appropriate amount of time, then you are risking that contract.
So I think that's the point I'm trying to make, is that you're putting your buyer at risk if you don't read it, understand it, communicate it to the buyer, what it means, and the fact that the buyer may ultimately end up waiting 4, 6, 8 months to get this closed if it has to go through probate. And so if we stick the buyer in a situation where they don't have an out because of the title work, they may ultimately have to wait, or they may have to wait at least until the end date of the contract occurs or passes in order to get out of the contract. So looking at the title work is a fundamental step. And that answers my next question, really. If the property is in a state which has not been through probate, what will an agent need to do? Again, you have to make the buyer aware of that and what the consequences are if they don't either terminate or ask for an extension of the contract so that they can go through probate. There are things that they really should be doing if they discover that information in the title work.
You could actually have someone who entered into contract that isn't in title. And that could be because they're either, one, buying on an unrecorded land contract. It could be because if you're dealing with an heir of the property, you need to know, if you look at your title commitment and you don't see your party's name and title, the person who signed the purchase agreement, there are questions to be asked. You need to find out the relationship between the person who is showing in title and the person who signed the purchase agreement. Sometimes there is an easy road to travel in order to get there, but the parties need to be able to explain what went on.
Yeah. Another one we run into quite often is trust. The property is being is owned by a trust.
Absolutely.
Sometimes the owners are still living. Sometimes the owners are deceased of the owner of the trust. So what documents do you need if you have a owner of a trust who is still living? What documents does the title company need in order to close that sale?
Sure. The first thing is, if possible, we need a copy of the trust, preferably a full copy. They can be pretty involved, and to ask somebody to go through and get specific pages can sometimes be daunting. Some of those things are a few inches thick and a 3-ring binder, and to ask somebody to go through it is difficult. So a full copy is preferred. We need a certificate of trust. It can be the original certificate. Based on age, we may ask for a new certificate or an affidavit of no change. If you have a party who is private and does not want to supply the entire copy of the trust, then you're going to be looking for things like the first page, a page that indicates who the trustees are, who the successor trustees are, their powers, their do they have the right to assign those powers, like by using a power of attorney. Most trusts do not give the right or the ability to use a power of attorney. So it has to specifically state that in the trust that they have the ability to do so. You also will need the signature page, so we can verify that the signatures in the trust are the same that are of the recorded documents of record. But most of the time, I have found, people have been very willing to supply their trust in full, allow us to make a copy. There are times where the county will require us to have the original. Sometimes that can get difficult, but it's always best to at least make sure that your clients have an original, just in case that it needs to be brought to closing or the county needs to see it.
When you say the rights under the trust, rights and responsibilities under the trust, is that described in the certificate of trust, or is there another document which provides essentially a letter of authority or an identification of someone who has the authority specifically to sell real estate for on the trust's behalf?
It can be in the certificate of trust. I have also seen a synopsis. Some attorneys will basically give you a 1 or 2 page synopsis of the trust that spells everything out. Most of the time, the concern with that is that it could be dated. That information can change, and we need to make sure that that information has not changed, which is where the certificate of trust comes in. If your certificate of trust is dated more than a year old, we may ask for an affidavit of no change or a new certificate be created. The protecting the identity of the people, knowing who is signing on behalf of that trust, is paramount. We need to know that the person sitting at the table and selling the real estate or buying the real estate on behalf of a trust is the right party. You don't want to unintentionally become a victim of fraud.
Great information. Let's apply that to a corporation for a moment. And I know that you brought some stuff, and I'd like you to share in the event that somebody is going to purchase or sell a property based on that they know is in title by a corporation, whether it's an LLC, an S corp, or a full corporation. Help us understand what documents there are.
Well, depending on the type of corporation is going to then dictate what we're going to need to see. There are articles of incorporation, certificate of existence, A resolution. If it's a Inc., then you're going to be looking for a resolution, a corporate resolution established by the board that gives the appropriate authority to an individual or a group of individuals to sign on behalf of the corporation. If it's an LLC, you're looking for, again, those articles of incorporation, certificate of existence, then also an operating agreement. In that case, the operating agreement should indicate who has the ability to sign, whether it be a member or a manager or, again, a group of either. So it really kind of depends on who or what type of corporation and then who is attempting to sign. Mm-hmm. And again, it's just making sure that you're not falling victim to fraud. You want to make sure that if somebody is signing on behalf of that corporation, then they're not running away with the corporation's assets or misrepresenting, sometimes simply just for the ease of getting through a transaction, but yet somehow down the road giving somebody the ability to object to that conveyance.
We have a question here, or maybe just a comment, that Tracy has... Hi, Paul. Come on in. Just have a cup of coffee. Tracy indicates, of course, there are different opinions on how agents should be involved in home inspections and inspection report, opening yourself up to unnecessary liability. It sounds like you're advising we be heavily involved in advising on the title work. I wonder, for the sake of our, if it isn't safer to advise the client to review the title work and contact the title agency with questions. We can't advise our clients on what we don't know. So let me make that very clear. I am not suggesting that if we read the title work and we don't know what it means and what the implications of it are, then by all means we should be on the phone to the title company to ask people like Matt. I'm seeing something that's called a memorandum of land contract here. What does that mean to my buyer? What does that mean if I see that there's a HELOC balance on the showing up on title work? Certainly the title people can typically answer the questions, but it's if we don't read it and do our best to provide exercise due diligence on behalf of our client, it's not going to remove our responsibility. We're not going to remove ourselves from the line of fire if a lawsuit happens by saying, well, we handed that off to the title company for answers. So I think that's just part of our job. We can't speak, we can't give answers that we don't actually know the answers to. We can't give a false answer, but we do need to know enough reading it, the title work, to ask the questions and get clarity that we can communicate, even if that means a conference call with a person from the title company to help explain it to our clients. That's my answer on that one. Moving on. Do mineral rights issues, oil and gas leases or options, usually show up on title work?
They do. The oil and gas leases, if they have first been recorded and have not expired, do show up on title work. If there are reservations for mineral rights, we will show those. Now, oil and gas leases, mineral rights, those are all exceptions to title. It's not something that is insured, but it is something that we do make the parties aware of if we're finding it a public record.
Okay, so if an oil and gas lease or option is recorded,
Mm-hmm.
How would you explain that to a potential buyer? Does that limit their rights to use the land or to access that property?
It can, but for the most part, I would say, in very rare instances, have I actually witnessed it affecting the use of the property. Most of the time, it is something that it's a potential. But if you think about that, if you're in a subdivision, what is the likelihood of someone coming in and starting to strip mine the subdivision? If you have a large meets and bounds parcel, if you're a buyer and you see that there is a pump on the property and it's active, I would start asking questions of the seller. Have people been out? Are you getting payments? What are some of the things that you've been experiencing? What kind of traffic? What kind of rights do people have? Do you have paperwork? These are things that the seller should, if they have an active lease and it's an active site, these are things that they should know.
I agree with you. They are things that the seller should know. And I know that having been in the oil industry down in Texas years ago, that oil drillers have the ability to drill spider wells as much as a mile away underneath properties. So, don't necessarily rely on whether or not there's a pump on the property. It may be an operation that's underway, half a mile or a mile away. If there is an oil and gas lease or an option for that, dig into it further and find out more about it for your client. Do recorded easements always show up on the title work?
At Star Title, they do.
Okay. Good answer.
There is general language that some title companies have used. If you see the words "if any" following an exception, easements, if any, covenants, conditions, restrictions, if any, if you're seeing that on your title work, that is what is known as general language. And what they're doing in that case is, instead of actually specifically setting out all of the individual documents that reserve rights or easements, they're just basically taking a generalized approach, saying they're out there, but we're not going to label them individually. We do take the time to go through and individually set out each and every easement or other exceptions that we find of title, other covenants, conditions, restrictions, building lines, all of those matters are set out.
I've got a question from Tim Creech in Jackson. Is Star able to help provide service when a buyer purchased the home via tax sale? Title companies in Jackson won't, and refer it to First American in Detroit, which is considerably higher in costs as they investigate the validity of the tax sale process. How do you respond to that?
Well, a lot of times they are going to require a quiet title. That's pretty standard between all the major title underwriters. Tax sales, it's a high liability area. Multiple times, title companies have been burnt on a poor process by the county. When they go out and they give the notices, that gets overturned a lot in court. So they'll go out and they'll send out certified mail. If that certified mail was found to be deficient in some way, it is a possibility that tax sale can be reversed. And it has happened enough that the title companies have just stopped insuring them.
Okay.
Now, in some instances, we can argue on the behalf of the client or the transaction and attempt to get the underwriter to insure those. But that is a rare process, and sometimes larger underwriters like First American or Fidelity will have those go to actual departments. And unfortunately, that is a lengthy process. and can be costly, both in time and in money.
I've got one last question. We're running out of time. Who is responsible to contact the lien holder if a first mortgage or even a second mortgage or HELOC has been paid off but is still showing up on the Schedule B?
Well, as a full-service title company, when we're doing the closing, our staff does that for you. In fact, I just had this today, where we had an old HELOC. The customer didn't know that they were signing a mortgage, and it was an older one. The bank had gone out of business, had been since sold to another bank. They didn't have any record of it. So in that instance, we then work with the bank up to a point. If the bank becomes unresponsive or simply just unhelpful, it is a possibility for us to then work with the consumer, the seller, to say, hey, I'm going to need you to go over to the bank, take your paperwork that you have, or we'll supply you with a copy of the recorded lien, and basically enlist them in the solution at a local level. A lot of times, if you're the seller of the property and you have a lien on there that you felt that was already paid off, you have a larger voice than the title company does, especially if for some reason we're having trouble with that. In this case, it was due to age. But for the most part, if it's a standard open lien, we're contacting the lender or the lien holder, depending on the type of lien. Again, we might need a customer authorization signed, but once we have that, the majority of the time we can clean that up.
Fair enough. Matt, thank you for joining us. I hope you got a lot of good information out of this today, and I will see you here next Monday. Have a great day.
Thank you.